Hi, everybody. Welcome to today's conversation on the POSHpod. We are in general, and when I say we, I mean Bishen and I, we are in general looking at the POSH Act. We are exploring some of the construct and guidelines around the Act. And Bishen, the questions I'd like to ask you today really focus on the concept of anonymity within the Act, right? So as an external member, something that I get asked a lot, why does the complainant have to identify herself? We know she has to submit her complaint in writing. Any circumstances in which she can stay anonymous?
Fair question. And just for the viewers who joining in for the first time, the background here is Lakshmi sits on a lot of ICs. So Lakshmi has real life experience in dealing with many of these matters. I am a lawyer, so I often advise clients on the technical side of this. So together we hope to address this question for you about whether complaints can be anonymous or not. Yeah, so Lakshmi, on anonymity of complaints, now the language in the law leaves a little bit of ambiguity, right? Because the law says the complaint has to be written. The law says the complaint has to be by an aggrieved woman, right? Both of those factors can actually still be satisfied and the complaint be anonymous. It can be by an aggrieved woman and be in writing but anonymous, right? So the law doesn't really say it should not be anonymous. But the law on this is quite settled. Cases have addressed this question in multiple decisions, one of them being Manjeet Singh. And the position is quite clear that the complaint cannot be anonymous, right? And there is good reason for why the complaint cannot be anonymous. It intends to protect not only the respondent but also the accused. Because for a respondent to be able to answer a complaint, to address an allegation, he needs to have, and I say he because the law currently protects women. It can also be a woman harassing a woman, right? So the respondent needs to be able to have enough information to rebut the allegations. Where did the harassment happen? Whom did he harass? When did he harass? It's important so that otherwise the respondent is left without having a fair chance to respond. So that's point one. Two, from the side of the victim herself. Now, if you allow anonymous complaints to happen, you open the door for complaints to come from third persons on behalf of a victim. And the victim may not want to be part of that complaint process for whatever reason. You cannot decide for the victim that you now need to be part of a sexual harassment proceeding. They may have many reasons why they don't want to be. One, because they don't perceive it to be harassment, possibly. Two, because they have a relationship with the individual. Three, because they may be from a background where it's not looked well upon in their social circles. Whatever that reason is, we are no one to judge what those reasons are. So by allowing anonymous complaints, you open the door for situations where a complaint may go which a woman does not want. So those are some of the reasons for why anonymous complaints aren't allowed. Lakshmi, have you seen this happen in your experience?
Well, I actually want to bring the flip to that, where primarily international organizations, larger organizations, talk also about other policies that they have. Like, for example, they have a bystander policy, or they have, an anonymous tips. A whistleblower, a hotline, a whistleblower policy. And there's a little bit of questioning. I'm not going to say concern, but a little bit of questioning in terms of exactly your point. Isn't it better to allow anonymous complaints? Because then from a workplace culture perspective, challenges get floated up. When we are talking, especially in India, when we're asking a woman, I want you to tell me exactly who you are, what was the problem you faced, and hey, welcome into this room where there are going to be 4 people who are going to be asking you questions about your experience, right? So there seems to be kind of a little bit of some kind of questioning around the understanding of that. Yes, the anonymity is, rather I should say the self-identification is important. And being on the IC, my perspective has been, if I don't know the context of the complaint, what am I going to investigate? Right? Because the whole point of the IC receiving a complaint is for them to do something about it. But if I don't know who's complaining, I don't know about whom the complaint is. And I'm just given, in general, something happened in our team outing last month. I don't know which team, which outing, who exactly. So I just feel it defeats the purpose of the investigation. It is a challenge, though.
Okay, so we discussed the complaint having to come from an identified person, but I'm sure as a member on the IC, you're also dealing with, even where the complaint comes from an identified person, you're dealing with witnesses who say, no, but I don't want to be named, right? For whatever reason. I'm scared, or my people may lash out at me based on the witnesses' statements I'm giving, etc. What has been your reaction to that? How do you deal with that?
That has been huge. That has been actually even more, right? Where two types of witnesses or two types of situations. Complainant says such and such person has witnessed this situation. IC says, hey, let's have a conversation with that person. But that person does not want to go on record. Absolutely no is a no. And that's something that it's more in terms of an educational thing with the witness to say that, look, it's important for you to tell us whatever it is. And just because you're coming as a witness or you've been named as a witness by the complainant, it does not automatically mean that you have a preset story to tell. Tell us whatever is your take or your perspective or what you've experienced. So that's kind of like a slightly long drawn out process, right? And then interestingly, we've also had situations where a witness, exactly to your point, witness says, hey, I am directly reporting into the respondent. He's my manager. So while I know that, I know something about the situation, and I'm willing to tell you, the IC, about it, but I don't want my manager to know that I'm the one who has told you. Right. So can you, can you accept me coming in and talking to you without telling anybody that it was me?
Yeah.
Right. So which then leads to a completely different kind of conversation.
So the answer is that you cannot disregard that evidence, right? If you have a witness who's saying that he or she saw whatever they saw, you can't disregard that evidence, but if the witness is not willing to be identified, there is naturally going to be a question of how much weight you can give that evidence, right? Now, let's take one step back. What is the obligation under the law with respect to witness anonymity? One, the law is very clear that to a third party, to an outsider, the IC cannot disclose the identity of the witness, right? So I think ICs should also give that comfort to a witness that we have an obligation, a legal obligation not to disclose your identity. That's step one. That may not be enough for a witness. A witness may still be concerned about their identity being disclosed to parties to the complaint, who is a respondent. Like in your example, they are worried that there will be, lash out from that individual. Now, how do we deal with that? Now, answer is, if the witness is not willing to disclose the identity, there is naturally an issue with how well the respondent will be able to rebut the testimony of the witness. And there are judicial precedents to say that as part of an investigation process which follows the principles of natural justice is the phrase, which includes giving the respondent an opportunity to cross-examine the witness, right? So that the respondent is able to say that no, the comments of the witness, the testimony of the witness is not false because of the questions I've just posed and I've rebutted that. Now, if that opportunity is not there, naturally the full weight cannot be given to the evidence being provided by the witness. But evidence can be of various forms, and this need not be the one piece of evidence on which the entire matter shifts. Right? If you have other pieces of evidence, the evidence provided by the witness could corroborate that. Right? For example, if the respondent has been able to question two other witnesses who have not objected to being disclosed, and the effects of that cross-examination are that the witness was telling the truth, and this third person who is saying the same thing has not been cross-examined, there is a good chance that she or he is also saying the truth, and therefore we can give weight to that evidence as well. So it's possible to give weight to it, but to a lesser extent, and I think that's the law around it.
That's interesting. So I'm going to actually share with you a specific situation, right? So team outing, annual day function, whatever it is, but the incident happens in a resort, not at the specific workplace. We know the Act very clearly says when it is part of the official listing, then, any sexual harassment that occurs in a situation like this, in the team outing, can be regarded as an extended workplace. So we've got that kind of settled, right? What happened in that particular situation was that because it's a resort, this young woman has gone to the ladies' restroom. She says that the respondent whom she has named followed her. Right, and then went on to share some details about that particular experience of hers. Now, we did have a couple of other women who were inside the restroom when the complainant came in, and clearly distraught and everything else. So we do have some. I'm using the term eyewitness, but people who saw that. We also had this other person, exactly like I said, who was reporting into the respondent, and who said, I saw him leave the dance floor, where all of us were. It was roughly around this particular time. And I noticed that, I can't say that he was following the complainant, but I did notice that the complainant was, going a little ahead, and he was behind her. So when the IC, when all of us in the IC were listening to this, again, there is this whole this challenge of from a gut feel perspective, we did genuinely believe what this person was saying. And then there was this, exactly to your point, is it fair for us to accept what this person is saying when they have very, very clearly and categorically said, don't bring my name into it, right? So then what we were discussing is, can we share this information with the respondent by redacting the witness's name, by saying that somebody came to us, because telling us in the IC was an official thing, right? The witness did come and did depose and did formally share this information. Leave my name out of it. So is that an option that we could have maybe explored?
You could do it, but I'll tell you why it's not adequate, right? Imagine this person, Rama, is the one saying that I saw Rahul following Anamika, okay? Now, if you had told Rahul that Rama at 7:30 said that she saw you following Anamika, Rahul may have been able to tell Rama, but at 7:30 I saw you and Rishabh, who was standing at the bar at 7:30, and just ask Rishabh. He'll tell you that she was there. She couldn't have seen this. Right? Now, you haven't given Rahul the benefit of Rama's name. And even though Rama may have been at the bar with Rishabh, Rahul is not able to rebut that. Right? Therefore, it's not adequate. That's why I said you cannot rely purely on that evidence. But let's say in this situation, apart from Rama, there was also a Rashmi who saw this happen. Right? And Rashmi is willing to come forward. And Rahul is asking her questions and not able to de-establish the fact that he followed Anamika, right? In this case, you could possibly also give some weight to the evidence given by Rama. But Rama's evidence alone, I would not say would stand the test before a court in case it is challenged.
Interesting. So what we're saying is that if this supposedly, partially anonymous witness, right? Because not anonymous to the IC, but anonymous to the respondent. If the information shared by the partially anonymous witness adds weightage, adds context, adds gravitas to something that is already available with the IC, then it
you can use it to further establish the allegation, but as opposed to establish it in the first place.
Okay.
Right? But it's not to say that a witness should be pushed, and I want to make that point clearly to IC members as well. It's not that you should push witnesses to state their name, because they may have genuine reasons for why they fear for their job, they fear for their promotion, fear for their bonus, fear for their safety. And therefore they may not want to. So if they don't want to disclose their name, that's fair enough. But the IC will naturally have to weigh the quality of that evidence accordingly.
And from the IC's perspective, again, there is that internal challenge, right? Complainant has come to me and told me, the IC, what the situation is. There are 3 people who are, I'm using the term in lay English, not in legal English, but basically corroborating what the complainant is saying about how the situation played out. But none of them are willing to acknowledge their identity as a witness. What if witness says, or even complainant, what if either witness or complainant says that, hey, I see, I'm fine. I will tell you who I am and this is what I saw. But when the cross-examination happens, which is obviously, again, part of the principles of natural justice, I don't want to be in the room with him. Yeah. I don't want to look at him when this is happening.
Perfectly fine, right? And there is case law on this point as well. You don't have to force the victim to confront her perpetrator, right? That's not a requirement under the law. The requirement is to give the respondent an opportunity to cross-examine. And there are multiple ways of cross-examining without them being in the presence of each other. Sure, you may lose a little bit of the benefit of being able to gauge body language and facial expressions and that instantaneous reaction. But you have to trade that off against the comfort of the victim, as well as the safety of the victim, and giving the respondent the right to cross-examine. So you can do this by, say, through the IC being the mediator, where IC receives questions from the respondent, poses that to the witness or the complainant, and receives the answers, passes them along, and vice versa, right? You can also do this through, sometimes complainant and the witness may not want to confront the respondent, but may be okay with being on a call. Right? Without being in the same room or without being on a video call, they may be fine with being on an audio call with the respondent. That's an option that you can consider as well. So there are ways in which it can be done, virtually, physically as well.
So from an IC's perspective, and now I'm wearing my Excel member hat, right? Two challenges to that. One is this post office business, right? I mean, you give me a question, this is your answer and stuff like that. It takes a lot of time. And it takes time in the sense of actually physically the IC getting together in a room and meeting time. It also takes time in the sense of I the IC ask the witness for the questions. Witness says, okay, I'll send them to you tomorrow, and then they come and then I send it to the respondent. And it eats into my 90-day deadline as well, right? So what could be I don't know, a good practice to manage that timeline? Is it possible for me, the IC, to tell the witness, send me your written, whatever response to the cross-examination questions? You have 24 hours to respond. Is that okay?
Absolutely. So there is no legally stipulated timelines in which respondents and witnesses or complainants have to provide questions, provide answers, right? It doesn't exist. So we have to just, in this situation, follow the principles of reasonableness, literally is all it is, and fairness, right? If you tell the witness that you need to respond in 2 hours and this is challenged before court, eventually the court will probably say that you didn't give the individual enough time to reasonably respond to such complex allegations, right? But if the questions being posed are of a yes or no nature, which don't require much preparation, maybe even 2 hours is fine. Wow. Right? Okay. So IC has to be reasonable about what is the nature of questions that you are posing. Is it something which requires research, looking through your emails, preparation, or is it something which is very factual and can be answered easily? So even 2 hours is fine, but if it's more complex, you must be reasonable, give 2 days, 3 days. That's broadly the process to be followed in these situations, I'd say.
All right. Fascinating topic. And, running out of time. But there's one specific question that I'm going to ask you. That's really around, again, the law saying that as a complainant, I cannot bring my lawyer into the proceedings, right? But if we're doing audio call, we're doing a digital call. Let's talk a little bit more about that, when we meet again. But good to know, good to understand about the difference between anonymity and proximity, that you can stay, maybe even in 2 different meeting rooms, right? I mean, as long as that separation and that comfort level is there. Bishen, I can go on forever. If we go back and ask organizations, so what do you think? Any questions that you have? I know that there will be several of them, but thank you for your time. Really
Before we sign off, though, I do want to address one little point which I think companies and employers will want to know about whether they can have a separate policy for anonymous complaints. Right? So while we discussed everything about whether complaints can be anonymous or not, and we said you don't have to take it up, can you anyway have a process to deal with anonymous complaints? Right? And the answer is yes. Nothing stops you. Right? And I would recommend that you in fact have those policies, because so that it informally you become aware of incidents in your workplace. You may follow your other disciplinary processes to deal with them, because you will have disciplinary processes to deal with employee misconduct, which can be theft, bad behavior, bad language, insubordination, whatever it is. For those kind of misconducts, you have a separate process. Follow that process for anonymous complaints as well if you are able to. And if the anonymous complaint is quite clear on who the accused is and what they have done, go ahead and give them an informal warning, not a formal warning, because that's a sanction as well. Go ahead and have a conversation with them. Say, we have come to know about this. We don't know if it's true or not, but it's come to our notice. If it's true, I mean, consider this to be like an informal warning. But it cannot be formal, because that's a sanction as well. So, I mean, there are steps that an employer can take and have processes in place to deal with anonymous complaints, as opposed to just saying, oh, it's anonymous, we don't, bother with this at all, and just brush it aside. And then 1 week later, something happens and you realize, oh, if I had taken that complaint into account and done something about it, maybe I could have prevented something in the future. So, I mean, I would urge employers to, not completely disregard anonymous complaints.
You really hit at the heart of the Me Too movement, right? I mean, it's so interesting, because what research is telling us, what the women under the Me Too, tag are telling us is that, look, if you had dealt with my complaint in a timely manner, I wouldn't need to go, ballistic like this. So once again, thank you. And hey, listeners, if you've liked what you've heard and you want to hear more, you know exactly where to find us. Come back and look for us. We'd love to hear from you. Like, subscribe as always. And questions, comments, we're definitely interested. Thank you.
Thank you. Bye-bye.